Welcome everyone to the Judiciary Committee hearing. We have two agendas this morning, one at 9:30 and one at 10. Decision making only at 10. If we have a crash on the Zoom side, we'll try again on Tuesday, February 27 at 9:32 a.m. in this room 016. It's a 2-minute time limit on testimony in person or on Zoom. And yeah, that's it. First up on first bill today on the 9:30 agenda is SB 2219 relating to lobbying, amends the definition of lobbying to include certain communications regarding procurement decisions, staffing, or appointment decisions, the development of an administrative agency's written report or statement of policy, and ex parte communications regarding contested case hearings. First up on 2219 is Robert Harris, Executive Director, General Counsel for Hawai'i State Ethics Commission. Morning.
Thank you. Good morning. Aloha. My name is Robert Harris, testifying on behalf of the Hawai'i State Ethics Commission in support of this measure. I appreciate the opportunity to be in your remote Alaska location. The temperature is frosty. I'm aware of a significant amount of social media raising concerns about this bill, and I would like to, if you don't mind, briefly address that. The intent here is to not in any way infringe upon citizen engagement with the legislature. And if there's any misunderstanding on that, I really want to make sure it's clear and straightforward. The definition in this bill is the same definition that's been in the lobbying law since 1971, I believe, which is anyone who is paid or receives other compensation to communicate with the legislature on legislative matters or administrative rules can be defined within the lobby as a lobbyist, and a certain amount of lobbying was allowed up to 5 hours per month or 10 hours per year before they were required to register. The intent here is specifically to deal with that last part of trying to determine when is a certain amount of lobbying occurred such that you would need to register. And the 5 hours definition was sometimes hard for both lobbyists and the Ethics Commission to apply. And the intent was to try to create a bright line standard that was easy for folks to apply. Recognizing the significant amount of concern, I think this language has come up, I'd rather not have it undermine the broader intent of the bill, and would be comfortable if this committee were to determine to take out that language for now, simply to allow the rest of the bill to move forward, because it is a very significant change. Again, I'm simply saying that I think there's a misunderstanding here. Would like to try to clarify it, but also, for purposes of moving the bill forward, would rather not let this become the reason why the bill potentially has impediments. Speaking more broadly, really do see the importance of this bill, specifically in how it will start applying to the procurement process.
Thank you very much. Next up is Ted Kefalis, Director of Strategic Campaign for Grassroots Institute of Hawaii. With comments, next is Jamie Detweiler, President, Hawaii Federation of Republican Women. Good morning.
Aloha, Chair, members of the committee, Senator Elefante. Jamie Detweiler, President, Hawaii Federation of Republican Women. I appreciate the clarification of the first testifier this morning. It does help in discerning the intent of the bill, and I appreciate that very much. I want to direct your attention to part of the bill where it references section 97-1. The proposed amendment is to amend the current definition of lobbyist to include any individual who for pay, which the first testifier talked about, or other consideration. So I'd like to make a friendly recommendation for a friendly amendment to remove other consideration. The other area of the bill that concerns me is changing the definition of lobbyist to mean any individual who engages in lobbying in excess of 5 hours in any month, and so on and so forth. Clearly, this is a slippery slope that we're going down right now in terms of impeding our the First Amendment of our Constitution, which is the freedom of speech. And so I just make those friendly recommendations for a friendly amendment. And I want to leave you with the words of Queen Lili'u Okalani. You must remember never to cease to act because you fear you may fail. And finally, John Adams said, "Posterity, you will never know how much it costs the present generation to preserve your freedom. I hope you will make good use of it. May I remind you that our actions today will impact future generations to come. Please vote no on SB 2219. Mahalo."
Thank you. Next is Andy Crossland on Zoom.
They're unavailable on Zoom.
In opposition, next is Alfred Medeiros, also on Zoom.
Yes, they are here on Zoom.
Good morning. I think you're still muted. Well, you were unmuted for a second, but you're still muted. Okay, go ahead.
Okay, aloha mai kako, offer kakiona Medeiros koinoa, no wainai mayao. I'm in full opposition of SB 2219. The first person who testified, you're not even from Hawaii, you're from Alaska, go home. Basically, the people who are voted into office, our delegates that you guys are voted from the people, us, the public. Now, putting us in a position as a lobbyist, anytime we are against any of these bills or in support, is completely ignorant and biased in every single way. You know, I'm not a lobbyist. I'm a loyalist to the people and for Hawaii. That's why I speak up all the time. Putting myself into any type of criteria or to put myself as a lobbyist, I would never be. I don't work for a politician. I don't speak on certain bills. I speak for the people and against anything that is not Pono in Hawaii. So I'm in full opposition, and I hope the people can listen to the other person that just testified, the second lady, and amend a lot of these things, or at least completely abolish it or push it to the side, because it has to be stated better. If that person who's from Alaska says that there's certain things that needs to be changed, well, do a better job on putting a better bill that's actually for the people, because right now it sounds like you're completely against people testifying and be opposed against anything that is hewa in Hawaii. And somebody like myself that shows up every single time when bills actually speak to the people, that'll be against what we're supposed to do. I'm not like, and mahalo for you guys' time for all of this, and sorry I had to put on the side of the road to be speaking on this. I wanted to be there in person so you guys can feel that energy that we bring to this every single time we're in those rooms. You guys got to remember, first and foremost, you guys work for the people. That's your guys' job and obligation, to listen to the people. Do better in 2024. This legislation season could be the change for you guys to actually listen to the people instead of only listening to them when it's voting season time. Aloha and have a blessed day.
Okay, thank you very much. Just for the record, I don't believe the executive director of the Ethics Commission is from Alaska. He was simply commenting that it's so cold in the room today that he thought that we were doing a field hearing in Alaska, so that was just a joke. Let's see, what else we got on this bill. That's everybody who signed up to testify in person. The total count was 1 in support, 143 opposed, with 4 comments. Most of the opposition, I believe, was to the 10 testifier rule that you would still have to be a lobbyist. You still have to be paid for your work, but it was a way to an attempt to make that a little clearer. So does anyone else wish to testify on SB 2219 here in the room or on Zoom? Okay, seeing none. Member questions? Executive Director, if you don't mind. So let's see, I had a couple of questions here. The first one was about the 10. If we were to just raise the number to 20, I mean, you still have to be, the bill clearly says you still have to be a lobbyist, you still have to be paid by somebody else for what you're doing, but would a higher number be any good for the commission? If we went to 20 or something, would that still fulfill the purpose that you had in mind, or is it just, is there something special about the 10 range?
I think the calculation was looking at approximately 30 minutes on average to review, draft, submit, log into the website. And so that was a calculation of getting up to 5 hours.
Okay.
That being said, I think it might be easier simply to remove it. I fear that even with 20 pieces of testimony, you'd still see the same level of concern. And I think, maybe it'd be simpler to remove that language.
Okay. The other question had to do with, you had a proposed amendment to the proposed SD to, let's see, it was a change in the definition of something to do with the procurement side, I believe. Can you explain that amendment?
So we had a proposed amendment specific to working on behalf of a client or working on behalf of somebody. We were contacted by somebody who was a professional and was concerned that because they were representing a broad swath of clients, that could be misconstrued to them. So we proposed a tighter definition specific to employment, that you have to be employed, and that would be presumed that if you were testifying on a matter specific to your client, to your employer, that we can presume that that's on behalf of your employer.
So what the employer would mean, a client or an actual? Like,
we actually defined it as employment, so no longer using the word client.
I see. Okay.
So trying to be more restrictive.
Okay, so it's more restrictive than that's what
Correct.
I was trying to drive. I couldn't quite figure out whether it was more or less restrictive. Okay.
I think the intent was we do not want to have a professional, say a lawyer, doctor, CPA, who has a broad swath of clients somehow being implied that you're testifying on behalf of those clients. And so we are trying to make the definition much more specific to if you are employed by somebody and you're testifying on a matter relevant, specifically benefiting your employer, that there can be a presumption made that you're testifying on behalf of that employer.
Okay. Senator Elefante, yes, go ahead.
Yeah. Just one question, because I was at the county for many years. I know there's county ethics, and oftentimes when people that were paid, whether they're architects or designs, if they had different projects before certain county councils, our office had to tell them that if you're not registered, you need to register as a lobbyist and file with the Ethics Commission. So how does pertaining to this and the interface with county ethics commissions apply? Like, what's that relationship and follow up for that?
Yeah, sure. So again, under the Constitution, it creates both state ethics and county ethics. And so the counties regulate their own lobbying laws. So this would not be applicable to counties in any way. It would only be on the state level.
Side.
Interaction with legislators, interaction with state employees on legislative matters. So in this regard, we don't see it as frequently. We don't deal with building permits, obviously, or building projects cut the same way counties do. But if somebody were hired to communicate on behalf of a person specific to legislation, and they triggered that 5 hours, then yes, in that situation, they would be required to register.
Okay. Thank you, Director Harris. Thank you, Mr. Chair.
Thank you. That's all the questions we have. Thank you very much. Thanks for being here. We'll go ahead and move on to the next bill, which is SB 2487. This repeals criminal penalties for possessions of 1 ounce or less of papalola. First up on this one is John Ichinaga, public defender, or someone else from the public defender. Good morning.
Hi, aloha, good morning, Chair and committee members. My name is Deputy Public Defender Taryn Tamasa. I am the supervisor of the Oahu District Court Misdemeanor Section. The Office of the Public Defender strongly supports this bill. The office is in support of the decriminalization of cannabis, as 24 other states have already done so. And I'm available for questions later.
Okay, thank you.
Thank you.
Next up is Corey Young, Deputy Attorney General, on Zoom maybe? No, in person. Good morning.
Good morning, Chair, members of the committee. My name is Corey Young. I'm a Deputy Attorney General with the Criminal Justice Division. We thank you for the opportunity for allowing the department to speak on this matter. 2 major concerns. The first concern is specific to page 2, line 6 of the bill, the striking of the term marijuana from 712-1249 subsection 1. We're concerned that that might actually open a hole where marijuana for promoting a detrimental drug in the 3rd degree actually will not be covered as a violation or a crime. It'll essentially create a hole where subsection 2 still talks about a penalty that would be attached, but the actual possession will not be covered by that statute. So we're afraid that that would open at least a hole between 1 and 2 ounces, potentially a hole simply below 2 ounces, where it's simply not conduct covered at all by promoting detrimental. Third, our more general concern is that at these amounts, raising the decriminalized amount to 1 ounce is essentially taking the current 3 grams and multiplying it by over 9 times. That's not a subtle distinction. We're going from essentially user or casual user amounts for a few joints to 28 grams, enough for anywhere between 50 and 70 joints. So for us, we're looking at that as more dealer quantities or distributor quantities. So we're going from a current situation that is protecting users to a situation where you would, through the passage of this bill, be much more looking towards the protection of people dealing the drug than simply using the drug. It's akin to saying, well, the speed limit at 25 miles an hour is a little too slow in this area. Let's raise it to 200 miles an hour. It's not a subtle change. We're going from 3 grams to over 28 grams. We would also just point out, if the eventual goal is legalization, this is a hard step in the wrong direction, because it's going to essentially entrench the black market for marijuana while providing the community with none of the positive benefits that are linked to legalization. Like, thank you for this opportunity to testify. I'll be around if there's any questions.
Thank you very much. Next up is Mike Lambert, Major Narcotics Vice, Honolulu Police Department. In opposition, next is Paul Moe, for the prosecuting attorney for the city and county. Good morning.
Good morning, Chair Rhodes and committee members. I'm Paul Mao, Chief of Staff of the Department of the Prosecuting Attorney. I'm here in strong opposition to SB 2487. Just 5 years ago, the legislature decriminalized the possession of 3 grams or less of marijuana. 3 grams of marijuana yields 6 to 7 joints. The penalty for possession of 3 grams is currently a $130 fine. This bill would decriminalize a full ounce of marijuana. 1 ounce of marijuana yields 60 joints. We aren't talking about personal use anymore. This is a quantity that could be sold, and the fine could be reduced to something less than $130. Let us not forget that the marijuana of today is far more potent than the marijuana of the past. The marijuana of today has 10 times more THC content. This bill allows a high potency drug to be used in far greater amounts for non-medical purposes. By reducing the penalties, this bill sends the wrong message to our keiki that marijuana is okay. Scientific studies warn us about the detrimental impact marijuana has on young developing minds and their long-term mental health. Marijuana use results in a multitude of problems: reduction of tourism from our critical Asian visitors, increased accessibility and distribution of marijuana to our children, increased traffic collisions and fatalities, increased chronic mental health problems, which include schizophrenia and substance use disorder, increased medical emergencies related to their use, and further growth of the black market suppliers. This bill should not be passed. It is completely unnecessary when we already have decriminalized the possession of 3 grams or less and provide medical marijuana for those with a legitimate need. Keep Hawaii, Hawaii, and not encourage harmful marijuana use. Thank you for this opportunity to testify this morning.
Thanks very much. Next is Addison Bulasan, council member for Kauai County Council. In support. Next is Carrie Ann Shirota, Policy Director for the American Civil Liberties Union of Hawaii. Good morning.
Aloha, Vice Chair Committee members, Carrie Ann Shirota on behalf of ACL Hawaii. We strongly support this measure. As we testified at the legalization hearing, the government should tax, regulate, and decriminalize at minimum. This touches upon individuals' personal autonomy, right to use, whether it's cannabis or a cocktail. If we were to apply the logic that we just heard from the prosecutor's office, then the government can overreach and also ban, criminalize alcohol use, because we know that it's deadly. And in contrast to alcohol, which many people die and there's violence-related incidents, the CDC does not have any category for deaths related to cannabis because it does not exist. We just want to point out that cannabis-related arrests is an entry point into our criminal legal system. We already have a bloated criminal legal system. We should decriminalize and increase the amount. And even if we decide to pass the legalization bill, that bill will not be implemented for 2 years. So in the interim period, we would like to see the amount increased. And as a reminder, it appears the federal government is moving to reschedule and classify as 3. And if you can see in our testimony, on the 3rd page, we point to data from the Hawaii Attorney General's office. You can see the number of people that are still being arrested for marijuana possession. Up to 2022, which is the last data, 523 persons. So this is clearly impacting people. And once they have a record, we know that there are lifetime barriers to jobs, housing, and other life opportunities. So please pass this sensible legislation. Thank you.
Thank you. Next up is Karen O'Keefe, Director of State Policies for Marijuana Policy Project.
Good morning. Good morning. I'm Karen O'Keefe, the Director of State Policies at the Marijuana Policy Project. We support SB 2487, which would bring Hawaii's decriminalization law in line with other states and prevent more than 100 traumatic arrests every year, along with the life-altering criminal records for possessing a personal use amount of cannabis. More than 70% of Hawaii residents believe cannabis should be legal. Yet Hawaii has not only not legalized cannabis, but its decriminalization law applies to the lowest amount of any legal or decriminalization state in the US. No other state has an amount that's under 15 grams. 3 grams is paltry. It's not even 1/8 of an ounce. Most decriminalization and legalization laws apply to at least an ounce. In Ohio, it's about 3.5 ounces for their decrim law pre-legalization. This results in hundreds of traumatic arrests every year. As a reminder, this is only about possession. It's not about sale, which would still be a criminal penalty. I also urge you to amend the bill based on a similar House bill, HB 1596. That bill would also remove penalties for paraphernalia used to store or to possess cannabis. This is important because cannabis is usually not just loose, so a person can now be also subject to up to a $500 fine for the baggie that cannabis is in. Also, there's a blank in the bill, which I suggest you fill in with a $25 fine to reduce it from $130. A Fed survey found that 18% of Americans could not cover an expense of over $100. This $130 fine that's currently in place has a devastating effect on low-income individuals, making it hard to pay for food, rent, and medications. $25 is about 2 hours at minimum wage, which would be much more reasonable for something that people think should be legal. Also, there is language in the other bill I mentioned, HB 1596, that you could use to exempt paraphernalia from possession or use of cannabis to avoid having these duplicative penalties. Mahalo for your time and for the opportunity to testify.
Thanks very much. Next up is Nikos Leverance, DPFH Board President for Drug Policy Forum of Hawaii. Good morning.
Aloha, Chair, members, Nikos Leverance with Drug Policy Forum of Hawaii. We strongly support this bill. We believe that this was the threshold that should have been implemented 5 years ago when cannabis possession was decriminalized. Cannabis sales are still criminalized, but this would, as by the Attorney General's own numbers, take up to 500 people per year out of the criminal legal system. And I fear that not enough is being made about the Attorney General's and the prosecutors and the police's posture regarding this. What is the case for the continued criminalization of cannabis from their standpoint? I think they should just be explicit. They want to ensnare hundreds of people per year into the criminal and legal system and use it as a cudgel against those from under-resourced Native Hawaiian and Pacifica communities. So this bill is really important, whether you support adult legalization or not. It builds upon the success of the prior decriminalization effort. Before that, it was over 1,000 people a year who were brought in to the criminal legal system on cannabis possession. So this is a wise, judicious measure. I'm glad to see the support of the Hawaii Public Health Institute and the Hawaii Substance Abuse Council on this. Mahalo for the opportunity to provide testimony.
Thank you. Next up is Peggy Mirzwa, Director of Policy and Advocacy, Hawaii Public Health Institute. In support, next is Alan Johnson, Chair of Hawaii Substance Abuse Coalition, with comments. I'm really sorry, sir, in the back. I can hear what you're saying up here. If you'd like to come and testify, you're more than welcome to, and have your 2 minutes like everybody else, but otherwise, could you let the rest of us do our job? Okay, great. Thank you. Okay, that's everyone who's signed up on SB 2487 to testify in person or on Zoom. The total count was 15 in support, 5 opposed, and 1 comment. Does anyone else wish to testify on SB 2487? 2487. Yeah, come on up.
Yes, there is someone on Zoom who wants to testify as well.
Great. Let us do the in-person one first, and then we'll come back to Zoom.
Okay, thank you.
Good morning.
Good morning and aloha Friday. I'm Carolyn Martinez-Galoyu, the Rainbow Family 808, and I'm testifying for all of us senior citizens who are managing fibromyalgia, arthritis, and diabetes. And the number of medications I have to take it gets tiring every single day. And so I would love to have this bill passed, because not only for myself, but we need to get our workforce involved in this, because some of them have had a minor pot arrest, and that cuts them out of any federal job, any state or city job. And so this would open up the doors for them. And we need more people. I'm tired of seeing help wanted, help wanted. And the other thing is, let's keep Hawaii, Hawaii. Before I came here in 81, I knew about Pakalolo. I knew about, what was it from Maui? Maui Wowie, so it's not a new thing, folks. And we need to become a civilized society and not rely on all the drugs I take. So for that and every other reason I can think of, I'm not a very good supporter, but it's my personal use. And all those young people out there that ended up getting caught with a little bit of pot, they don't realize that curtails their future employment. And that is insane here in Hawaii. And so let us enjoy our Maui Wowie, or whatever it is that we do to keep us sane. And goodbye. Thank you.
Thank you. Okay, there was someone on Zoom that would like to testify. Good morning again.
Hello, my kako. Africa Maderas Koino, Noaina Mayao. I am a 3 to 9 card holder since the beginning. Been fighting for medicinal cannabis people's rights for 16 years. I was a former organizer of the Hawaii Cannabis Expo, and I'm in full support of this decriminalization completely, but for this bill. I believe the prosecutor's office aren't doctors. I don't know where he's got his statistics from, because whether it's 20 grams can produce 60 joints, or him thinking that cannabis is a drug. We live in a day now age where we're trying to go to a more natural alternative, medicine, instead of taking Western medicine that damages our liver, damages our kidneys. That's what I'm going to right now. I'm going to the doctors right now because I have stage 2 liver disease, stage 2 kidney disease. And it was everything because of what the doctors gave me, that a pharmacist actually signed a prescription for. A 329 card makes us able to have the option of choosing medicinal cannabis, a healthier alternative, instead of, giving us pills. I see people being criminalized. Either it's giving tickets or whatever it may be, just wrong, for a natural plant that grows from the ground, that comes from our aina. And for him to say that it deters tourism, which as a Kanaka, I'm fine with tourists not coming to Hawaii, but it doesn't. People from all across the world know about the Kona Gold, the Maui Wowie, and everything that we as Hawaii have grown throughout ages. So his facts is false. Simple as that. It's time to change the narrative. It's time to take away from the 50s and 60s, and we're in 2024, where medicinal cannabis changes the world, and it's helping everybody in every single type of way, whether it's recreational, whether it's medicinal, but decriminalization needs to be changed in Hawaii. So mahalo for you guys' time. Whoever put together this bill, mahalo. We appreciate you as cannabis farmers, as cannabis enthusiasts, and as cannabis connoisseurs. Aloha.
Thank you very much. Would anyone else like to testify on SB 2487? Okay, seeing none. Members, questions? Okay, seeing no questions, let's go ahead and move on to the next bill, which is SB 2557. This is relating to legal representation and repeals paragraph 3 of section 802-1A, which entitles the subject of a petition for assisted community treatment to legal representation by a public defender. First up on 2557 is John Hinaga for the public defender. Good morning again.
Aloha, good morning again. Taryn Tomasa on behalf of the Office of the Public Defender. The Office of the Public Defender supports this bill. It's our view that this amendment will bring the statute in line with not only the mandates of the Office of the Public Defender to assist those in jeopardy of the loss of liberty, which our position is that the AC petition, although similar to, does not reach that level, but it also makes it consistent within the statutes because the Office of the Public Defender had been previously removed, I believe, 2 years ago. So this is just a consistent statute to bring everything together.
Okay.
Thank you.
Thank you. Next is Carrie Ann Shirota, Policy Director for the ACLU of Hawaii. Morning again.
Good morning. Carrie Ann Shirota on behalf of the ACLU of Hawaii. We oppose this measure, but we offer an amendment that we can support. As outlined in our testimony, a few years ago, the state legislature made a decision to repeal the right to counsel in assisted community treatment, also often referred to in other states as assisted outreach patient treatment. This infringes upon an individual's right, again, to bodily autonomy, the ability to choose, or in the case of not choosing, medication. And while the government can at times impose medication through an order, et cetera, there needs to be procedural safeguards in place. In 2021, the Attorney General's office noted that the proposal of repealing the right to legal counsel was likely unconstitutional. The Department of Health also pointed out that they had serious concerns about this removal of legal counsel. We recommend that if you take a look at this as well as the assisted community treatment statute in itself, that if you remove the right to legal counsel by the public defenders, that you require and mandate legal counsel. So it does not have to mean necessarily the public defenders, but there should be legal counsel in place given the procedural safeguards that need to be present for that. We also want to point out that just on its face, that this statute, along with assisted community treatment, is really targeting a discrete minority, people with disabilities or perception of disabilities. And we need to ensure that the Bill of Rights, our Constitution, applies to everyone. And we would like to point out, in just a quick cursory research, we haven't done an exhaustive research, in the number of other states that have enacted this AOT, ACT, New York, for example, Kendra's Law, right to counsel is provided. California, Laura's Law, right to counsel. I've looked up a few states quickly last night. Utah provides the right to counsel, Washington State. So we just ask you as lawmakers that we respect people's constitutional rights. And while we're not objecting to act itself, the right to counsel needs to be implemented. Thank you.
Thank you. Next is Louis Ortischik for the Hawaii Disability Rights Center on Zoom. Good morning.
Yes, good morning, Senator Rose, committee members. Let me follow up on what Carrie Ann just said. First of all, this bill is clearly just a housekeeping bill. I totally got that. I mean, a couple of years ago when the law was changed, one section was not amended. So from that point of view, there's nothing in one way or the other inappropriate about this bill. What I'm suggesting in my testimony is that the decision that was made a couple of years ago, and I think Senator Rhodes, you and I think discussed that at the time. I respectfully don't think that was the decision I would have made, but you folks are the elected officials. At that time, the thought was that you have these poor mothers on the one side against the aggressive public defenders, and people weren't getting treated because of technicalities. But there is a bill coming down, House Bill 2159, that may come from the House. You introduced, I believe, the Senate companion. Now what you're going to do is you're going to have the Attorney General come in and represent the petitioner. So to me, the scales are substantially going to be tilted now. It's one thing to say, well, nobody's got a lawyer, so if they only have a GAL, it's not a big deal. But if the Attorney General is going to come in and represent the petitioner and they don't have legal representation, I think you have serious due process issues that you need to consider before you act. And not all lawyers are the same. A GAL may be a lawyer, but they're not acting as a legal advocate. It's just one more person who says, yeah, you probably ought to take your meds, which may be true, but it's not someone that's actually going to represent them. So I think going forward, I know this is a housekeeping bill, but going forward, this is a larger discussion that I think we need to have this session before we go ahead and bring the AG in whole hog. So thank you for listening to me.
Thank you very much. Next is Connie Mitchell from Institute for Human Services. Good morning.
Good morning. I'm Connie Mitchell. I'm the Executive Director for IHS, and we have a program that helps to find people who are mentally ill, have lost their ability to make decisions determined and assessed by a psychiatrist or an APRN-RX. These people are really in need of treatment, and the Act statute allows them to receive that treatment. I think we really want to clean up the statute so that there is no further confusion about whether they need an attorney. There is a GAL that's representing them, their best interests, and really we take the GAL to see the person so they can see for themselves and report back to the judge. I believe the judge is the person who provides that due process. The GAL actually facilitates that. And I think that we have demonstrated that when people receive the treatment that they need, they have a right to, as much as they have a right to civil rights, they have a right to treatment. And we have seen people who have been, disrobing in public, setting themselves on fire, doing all kinds of things, which really demonstrate to anybody that the person does not have the ability to make decisions. And so we just want to, make sure that we don't have this block to be able to help people further than we have. I think the delay, caused by having so much contentiousness legally has resulted in people actually dying, people losing limbs, people just, really experiencing hardship that is beyond or permanent, and it's really sad to me that that has to happen. So I really do support this bill and would like it to be amended so that it's really in line with the rest of the statute. Thank you.
Okay, thank you very much. Next up is Christopher T. Thomas, Attorney at Law, in support. Raylan Reno Yeomans on Zoom perhaps, or here in person. Good morning.
Good morning. Thank you, members of the committee, for letting me testify my strong opposition to SB 2557. Although this may be a housekeeping bill, I'm very concerned about the numbers of people who are currently under ACT orders, mainly under IHS, that have been subjected to forced treatment without any legal counsel present during their hearings. And that was a unilateral thing that this legislature did to remove their right to legal counsel and violating their due process rights to the 14th Amendment of the Constitution, as the Attorney General warned at the time. I am also a member of the PAMI Advisory Council for Hawaii Disability Rights Center. The PAMI Advisory Council exists because of the federal PAMI Act, which is currently administered by SAMHSA, the Substance Abuse and Mental Health Services Administration. The PAMI does stand for the Protection and Advocacy for Individuals with Mental Illness, and SAMHSA does have advisory documents out which does advise that these type of outpatient or inpatient commitment and forced treatment orders should always have a legal, the individual should always have legal counsel present. So again, while this may be a housekeeping bill, be aware that because of the actions of this legislature, people are currently under ACT orders and did not have legal counsel present. Thank you.
Okay, thank you. That's everyone who signed up for SB 2557. Would anyone else like to testify in SB 2557? Seeing none, members' questions? I guess for public defender. So your office is generally viewed as being pretty, well, I think sort of your motto is zealous representation of your client, no matter what the situation is. But you're okay with not having to deal with, not having to be assigned to assisted community treatment petitioner cases. Is that okay? Is that because your main mission is for people who are losing their freedom, like you can't leave this cell, kind of a?
That's correct. Who are in jeopardy of losing their liberty, either imprisonment or involuntary hospitalization. In the ACT statute, if it ever arose to a level of forced medication, they would have to petition for an involuntary hospitalization. So if and when it achieved that level of a loss of liberty, my office would become involved, because we are appointed for involuntary hospitalizations and involuntary medications.
Including ones that are the end result of ACTs.
They may or may not be the end result of an ACT. So I did participate in the ACT process, and notably, most of the individuals who are served with the ACT petition do not appear at the court proceeding, which is another problem. When we're zealously advocating for our clients, we don't even meet with those individuals. They don't communicate to us. Most of them did not want to communicate with myself when I was involved to tell us exactly what their position was, what they wanted to achieve. And so it really puts the public defender in a difficult position to even know what type of advocacy the client wants when they refuse to meet with us, when they're not required to meet with us.
I see. So this is an unrelated question, and I'm asking you just because you probably spend quite a bit of time in court. Does a family court judge have the inherent power to assign an attorney if they think that the interests of justice demand?
Right now, yes, they do.
They do. So even if we took out your, if we passed this bill, a family court judge sitting on an ACT case could say, you know what, there's something fishy here. I think I'm going to appoint an attorney. It wouldn't be you if we passed the bill, because you wouldn't have the authority to do it anymore, I think is my understanding. But they could appoint somebody.
The experience that I had, the court referenced this particular statute in determining whether they had the ability to appoint. I would note, though, that the JLs that I had worked with are licensed attorneys.
Okay, so I guess maybe I'm just not listening very well. So, but without the, if they could appoint somebody other than the public defender's office on their own authority now.
I'm not sure.
You're not sure. Okay, that's what I was curious about. Okay, thank you very much. Members, other questions for this testifier?
No. Basically, you covered it, because my experience has been, unless there is an actual enabling statute, the court cannot appoint one. And this bill removes that enabling ability. All right. That's my concern.
Ms. Mitchell, do you mind coming back up? So some of the more recent cases you guys have handled, I think my understanding is that family court judges have been concerned for some reason about the lack of legal representation.
That's not correct.
That's not correct. Okay, go ahead. Can you tell us
so
what happened?
What has happened is that a GAL has been now deciding that he's going to ask for the public defender to be involved in almost every case. So like we have about 5 cases that are resting on a decision by the court to determine whether that would be provided or not. And so it delays it. Like yesterday I was in court. That was filed originally in August of last year, and it is now February. And so it added more time, and we have another date coming up to find out whether we're going to proceed or not.
Okay. Okay, thank you. Thanks very much. Other questions, members? Okay.
Yes,
go ahead. Senator Simone.
IHS. So your understanding, well, I think public defender can come in more, but were there legal reasons as to why the GAL asked for the public or for a court-appointed attorney? Do you know in those cases? Because
A legal reason.
yeah, my understanding because I used to be a court-appointed guardian, and as the prior testified, judges usually do appoint attorneys to be court-appointed guardians. But because as court-appointed guardians, we have a certain mandate that requires us to act in the best interest, which may be in conflict with advocating for the individual. Has the judge, in appointing another attorney, found that there was a conflict between acting as a best interest as a guardian ad litem and as an advocate for the ward?
I don't think the judge has ever appointed another attorney, and partly it's because these cases that are brought before the judge are probably the most severe cases because of the people that we are able to medicate. It's not minor, but it's a lesser amount of people that we really need in order. We generally want to really engage the person enough so that they're making the decision to receive treatment. So it's really when the person is not able to participate a lot of times with someone who's going to represent them. In this case yesterday, the person is clearly very paranoid and not wanting to even talk to anybody. So even if the judge were to appoint an attorney, I don't know if the attorney would even have a chance to meet with her.
Okay, thank you.
Thanks. Other questions, members?
I'd like the ACLU.
Oh, okay, go ahead.
Same question. Do you see a difference between the two statuses, even though a guardian ad litem is a licensed attorney?
Yes,
And
because the standard is different. A guardian ad litem has a duty to follow the statute, which is in the best interest of the individual, versus a public defender or a court-appointed counsel has the right to protect their constitutional rights. So even if that person doesn't show up or doesn't want to communicate, it's again having that procedural safeguards in place. I think if we get to the place of like the judge or everyone else making the best decision, I mean, you can see how far-reaching this could go. Even in criminal defense cases, this idea that we can stand in the judgment. There are certain things that we need to absolutely have. And I just want to point out in California, this is really short, it says, this is under their Laura's Law. The person who is subject to the petition has the right to be represented by counsel at all stages of an AOT court proceeding. If the person elects, the court shall immediately appoint a public defender or other attorney. If able to afford it, the person is responsible for the cost of the legal representation on his or her behalf. But otherwise, that person would have legal counsel, period.
yeah,
Thank you,
very much.
Senator.
Okay, thank you. Other questions, members? Okay, if not, let's go ahead and move on to SB 2601. I guess that's next. Yeah. Expands the time period by which a civil action for childhood sexual abuse may be initiated. Right now, it's 8 years after the person's 18th birthday or 3 years after they discover it. And the bill would increase the statute of limitations to 32 years after the person's 18th birthday or 50, and 5 years after they discover or should have discovered. First up on 2601 is Lee Ying Kwok, a Deputy Attorney General, on Zoom maybe, or in person. Good morning.
Good morning, Chair Rhodes and members of the committee. I'm Deputy Attorney General Lee Ying Kwok, and I represent our department with respect to SB 2601. We previously submitted similar testimony on the companion bill to this one, HB 1968. While our office does not discount the right of survivors of sexual abuse to initiate lawsuits, we do have concerns with quadrupling the time period contained in the proposed statute of limitations. As reflected in our written testimony, expanding the SOL by decades will compromise the availability as well as the reliability of evidence in these cases. Under these evidentiary constraints, it becomes next to impossible for the state to defend lawsuits of this nature. Thank you for the opportunity to comment.
Thank you. Next up is Lynn Costellas Matsuoka, Executive Director for the Sex Abuse Treatment Center. Good morning.
Good morning. Good morning, Chair Rhodes and members of the Judiciary Committee. Lynn Costales, Executive Director of the Sex Abuse Treatment Center. We are in strong support of this measure. We ask that this committee pass this bill forward. We do recognize that there were some amendments made by the companion bill, which was, I believe the amendment was to allow civil suits by children starting on July 1st, 2024, those that were abused after that fact, because it has a prospective application, not a retroactive application. And we would ask that the 32 years is a compromise already. I think initially when this bill was submitted years ago, it was just eliminating the statute altogether. We're not asking for that at this point. We are asking that it be 32 years, which is typically when a survivor will come forward. Not always. Some children do disclose right away, but many don't, as we have seen in some of the litigation across the nation that has revealed some institutional sexual abuse of children. So in that regard, we are asking for this bill to be passed. And I thank you for your consideration, and I'm here for any questions that you may have later.
Okay, thank you.
Thank you.
Before we proceed with testimony, I'm going to take a 4-minute recess. Got to go. Okay, coming back out of recess on the Judiciary Committee for SB 2601. This is relating to sexual abuse of minors. Next up on 2601 is Michael Glow, Jr., Chair and SCC Representative for the Stonewall Caucus of the Democratic Party of Hawaii on Zoom. There you are. Good morning.
Good morning. Michael Glow, Jr., Chair of the Stonewall Caucus. We stand in support of this bill. We did ask for an amendment to remove the statute of limitations. We've already had a testing period, so all the people calling saying that the sky is going to fall, it didn't fall during that testing period. It won't fall now. We need to stop making Hawaii a dumping ground and a bastion for pedophiles. That is what we are doing here. We have some of the easiest statutes. If you just run the clock out, you can rape a kid and you can run the clock out. We need to stop that. We need to protect our keiki. We need to protect them, let them be able to come forward whenever they're able to deal with the trauma that is surrounding being raped as a child. As we've seen, we have these child pedophile protectors out there that have done their best to hide them from prosecution. We need to stop. We need to let them know that the clock will continue. We're not going to let the clock run out. Again, for the Attorney General's office, we've told them, and I've spoken to other Attorney Generals, and they're surprised in other states than other offices that the Attorney General's office is not leading the battle to remove the statute of limitations, because they say they're supposed to be there for justice for all of Hawaii. And by removing the statute of limitations ensures justice, at least attempted justice, for survivors of childhood rape. So we encourage the Attorney General's office to reach out to other states that have already done this. The skies have not fallen in the other states and other jurisdictions where they've removed the statute of limitations, and those the survivors have been able to seek some form of justice. So we encourage you to pass this bill with those amendments so we can move forward. Mahalo.
Thank you. Next is Michael Gloy, Senior Secretary Board Member for Rainbow Family 808 in support. Heather Lusk, Executive Director for Hawaii Health and Harm Reduction Center, also in support. Angelina Mercado, Executive Director for Hawaii State Coalition Against Domestic Violence, in support. Allison Uyaoka, President of Hawaii Insurers Council, in opposition. Next is Chris Caulfield, Co-Chair Legislative Committee for the Democratic Party of Hawaii, in support. And also for Imu Alliance, Evan Oe, for the Hawaii Association for Justice, in support. Cheryl Hauk said would be here in person, maybe on Zoom. No, in support. Mai Hall, Children's Health Coordinator for HCAN speaks, in support. Rane Hamilton Cambiel, Executive Director for YWC Kauai, in support. Carolyn Galoyu for Rainbow Family 808. Good morning again.
Aloha Friday on this frosty morning. Rainbow Family is a nonprofit organization. I am the president, founder, and an activist and an advocate. And I'm here speaking today for all those youth, all those women, adult women who are out there and have never, ever told anyone because of fear, because they've been threatened, intimidation, and social mores. You don't talk bad about others. Well, this is more than just talking about someone. This is more than sexual assault. They didn't just grab somebody's boob or their coli. They did more. And we have to stop being a haven for the rapist. I don't call them pedophiles, they're rapists, and that's a downright truth. And in my written testimony, I give a whole list of things. And I have been advocating for this bill, but for the complete erasure of the statutes of limitations. E. Jean Carroll wouldn't have had her day in court. And one of my friends, and she told me yesterday on the phone, please tell part of my story. Part of it is her high-ranking, her admiral father raped her. And she says to this day, she always remembers. There isn't a detail that she has forgotten because it was so pervasive and so ongoing. And so we have to do something, and we have to put a stop to it. And I know this bill doesn't call for the erasure, but I'll keep calling for an erasure since, until I can't walk in the door anymore, until I can't speak anymore. But we have to protect the children, bottom line. Thank you very much.
There's an additional 12 individuals who have written in support, but that's everyone who's signed up on SB 2601. Would anyone else like to testify on SB 2601 in Zoom or in person? Seeing none, members, questions?
Yes.
Senator San Buenaventura.
Sexual Abuse Treatment Center. So thank you for your testimony. I know that years ago, we have eliminated the statute of limitations for criminal penalties.
Correct.
So this is for civil, right?
Correct.
Action. And I don't know if I talked to you or other advocates, but every time this came into, and I'm sorry that my staff missed this because otherwise there would have been a re-referral to my committee. But my concern are the Alice families, because being a plaintiff's attorney before, we look for deep pockets. And if the rapist does not have money, we look for employers at that time. And so my concern had been, what is the cost for the insurance for childcare providers, for schools? And I had asked the advocates, and maybe you have the data, in whether or not this has passed in other states, and if so, what was the fallout?
Yeah.
How much of the insurance premiums increased for those? Because the Insurers Council is saying that because it is an unknown, there's a high likelihood these childcare providers, these schools will not be able to have insurance.
Right. And so I don't know the answer to that. That's the short answer for me, is that the civil statute of limitations has been eliminated completely in some states. Other states have a variation of it, sort of like this proposed measure. Its impact on insurance and child care, I don't know the answer to that. That's the part I'm unaware of. But I do know this, that while it is true that that there may or may not be, I don't know the answer as to whether there will be an insurance impact that will be passed down to a family who wants to, have their
all
child.
Expenses of a child care provider is going to be passed on, because otherwise they won't be in business.
But I will say this, some of a child in DOE, they are not incurring a cost to engage in public education. Someone who goes to a church is not incurring a cost to engage in a religious activity. And I think what we've seen is that some of the institutional abuse that has gone on across the country, here in Hawaii as well, that there is, that cost factor is not there for certain organizations where child abuse has occurred on a prevalent basis. So I don't know the answer on the.
Thank you. So, and because people did not provide me, because this has been going on for years.
Yes.
And each time it came to my committee, I asked the advocates, well, give me the data, and I haven't been provided data. So a companion bill to this, so that's why.
238, I think.
Right.
SB 238.
Right. I provided a working group.
Right.
To get the data. Because normally whenever insurance is an issue, we do an auditor's report to determine how much the premium increase is. Do you have any problems with either an auditor's report or a working group so that we can get the data so that we can ensure, because we don't have enough childcare providers now.
Yeah.
There are a lot of people who are unable to afford childcare, and you know that because you help the victims who can't find childcare for their own kids.
Yeah. You know, with all due respect, I do, I am in opposition of that, only insofar as I don't think we can put a price to it, you know, and that's how, as a parent myself, and having my child in early child education before she went to school, I get that, because the cost is so high for,
and we don't have enough.
And we don't have enough of it. So I do recognize that portion of it, but as a parent, you know, as an advocate for victims, I don't think we can put a price on taking care of kids.
Thank you.
Okay, thank you.
Other question?
Anybody else?
Other questions, members? Okay.
Thank you.
Okay, I think we are ready to do some voting. Senator Wall, would you like to take votes today?
No, they can do it. Thank you. Though.
You sure?
Yeah, go ahead. Thank
All
you.
right. Brennan? Sure. Sorry. And Senator Elefante?
Sure.
Okay. Do we need to break for decision making, or we're ready to go? Okay.
I'll keep my hands in my pocket.
I doubled up during the break.
Okay, so we'll go back to the top of the 9:30 agenda. That's SB 2219. This amends the definition of lobbying to include certain communications regarding procurement decisions, staffing, or appointment decisions, the development of an administrative agency's written report or statement of policy, and ex parte communications regarding contested case hearings. Well, I think that the many people testifying against the bill were mistaken about what it means. You still have to be a lobbyist no matter how many times you testify. You have to get lobbyist, meaning you have to get paid. I'm going to go ahead and hang on just a second. I can't see. So what we'll do is we'll pass the proposed SD. This was all the testimony was on the proposed SD. With an amendment, with two amendments, we'll accept the Ethics Commission's amendment to the proposed SD regarding when someone is ostensibly advocating on their own behalf but really are lobbying for someone else. We'll make it more restrictive, so it's only for the employer instead of for clients. But the language, we use the language that was in the Ethics Commission's testimony, and we'll just delete the 10 testimony rule completely. We'll just take that out, and we'll deal with that issue later. And yes. Okay. So in addition, we'll accept the technical amendments proposed by LRB, which would conform the preamble to the proposed SD1, change the term transaction to contract, change the term paying person to private client. Now, to the extent that these are inconsistent with the change that the amendment by the Ethics Commission amendment would be the one that we'll actually use. And we'll define private client as any person who makes an expenditure in exchange for the performance of lobbying services. And we'll correct a typo. Yeah, that's just a tag. Okay, questions or concerns? If not, Senator Elefante, thank you for taking the vote.
You're welcome. Okay, Chair's recommendation is to pass SB 2219 with amendments. Chair Rhodes.
Aye.
Vice Chair Gabbard is excused. I vote aye. Senator San Buenaventura.
Aye.
Senator Awa.
No.
Mr. Chair, your recommendation is adopted.
Thank you. Next up is SB 2487. This repeals criminal penalties for possessions of 1 ounce or less of Pakalolo. The recommendation here here's the recommendation. We'll pass with amendments. We'll raise the decrimmed amount to 15 grams instead of 1 ounce. And then we'll keep the fine for the decriminalized amount at $130. And we'll change promoting a detrimental drug in the 2nd degree to below, so the lower range will be 30 grams, which is slightly more than 1 ounce. And we'll accept the AG's amendment to not delete the word marijuana from the current wording in the statute for promoting a detrimental drug in the 3rd degree. So maybe not exactly what the sponsor wanted, but we'll keep it alive and keep talking.
Okay. My only comment is, and it was the same comment with the 3 grams, is other portions of the statutes refer to ounces and pounds, and this refers to grams. So
yeah, we'll try to get them all to grams eventually.
Okay, well, that was the thought back in the 70s. Anyway, didn't work.
Senator Elefante.
Thank you, Chair. I appreciate the discussion on this. I was going to go with reservations, but however, hearing your amendments, I'm comfortable, so I'll be voting up.
Okay, great.
Thank
Thanks.
you.
Other questions or concerns? If not, Senator Elefante.
Okay, Chair's recommendations to pass SB 2487 with amendments of the 4 members present on judiciary. Any no votes or votes with reservations? Hearing none, Mr. Chair, recommendations adopted.
Thank you. Next up is SB 2557 relating to legal representation. This would repeal paragraph 3 of section 802-1, which entitles the subject of a petition for the subject of a petition for assisted community treatment to legal representation by a public defender. So I think what I'm going to suggest, no point in beating around the bush at this point. I'd like to go ahead and pass it with an amendment, which would be, we'll go ahead and take the PDs off, which they seem comfortable with not being involved, at least until there's something where there's a involuntary holding or incarceration. But we'll give the family court judges in ACT cases the authority that if in the interests of justice demands, they can appoint legal counsel. And we'll see in the committee report. I'd like to also note that under current law, the subject of a petition for assisted community treatment can always ask for an attorney, but they never do because they're so mentally ill that they don't know what to ask for. So we'll leave a safety valve that if the judge in the case feels like, there's something else is going on beyond just the best interest of the patient that needs to be considered, he or she can go ahead and appoint an attorney to represent their legal interests. Questions or concerns? If not, Senator Elefante.
Okay, Chair's recommendation is to pass SB 2557 with amendments of the 4 members present. Any no votes or votes with reservations?
No.
No vote for Senator Awa. Mr. Chair, recommendations adopted.
Okay, thank you. Next up is SB 2601. This expands the time period by which a civil action for childhood sexual abuse may be initiated from through 8 years after the 18th birthday to 32 years after the 18th birthday, or 3 years after you've known or should have known to 5 years after you've known and should have known. Recommendation is to pass as is. I think so this is commentary now. I think the other states that have had to deal with the insurance problem have managed to deal with it. So as is the recommendation. Okay. Questions or concerns?
I've noted my concerns that I am severely concerned that our child care providers are going to have these added expense, which then prevents them from offering childcare. And we have a severe shortage of childcare in the state.
Okay.
And basically, we've already removed the criminal penalties, the statute of limitation for criminal penalties, so we can punish them. So this is basically asking for money. And I have no problems with asking for money from the perpetrator themselves, just like E.G. Carroll. But when it starts going towards employers and innocent people just to get money, I have severe problems. Thank you.
Okay, any other questions or concerns? All right, we'll see where the votes are. Go ahead, Senator Elefante.
Okay, Chair's recommendation is to pass SB 2601 as is of the 4 members present. Any no votes?
No.
No vote for Senator San Buenaventura. Any votes with reservations? Okay, Mr. Chair, recommendations adopted.
Okay, I believe that's the end of that agenda, yes? Okay, so we're done with 9:30. And we'll go ahead and go into the 10 o'clock decision-making agenda when you're ready for with the countdown.
Okay, sorry, we're still rolling, so you can start. You can continue on.
Okay, welcome everyone to the 10 o'clock agenda at 10:45. First up on, this is a decision-making only, so first up on this one is SB 2129. This expands the definition of historic property for purposes of the Historic Preservation Program. The issues at play in this one are clearly in the Waterland Committee's jurisdiction, and so I'm just going to put a bad date on it, April 14, 2112, and move it forward for further discussion. Questions or concerns? If not, Senator Elefante, thank you again for acting as Vice Chair.
You're welcome. Okay, Chair's recommendations to pass SB 2129 SD1 with amendments. Chair Rhodes.
Aye.
Vice Chair Gabbard is excused. I vote aye. Senator San Buenaventura.
Aye.
Senator Awa.
No.
Mr. Chair, recommendations adopted.
Thank you. Next up is SB 2236. This requires law enforcement to post notice that a warranted or warrantless search has been conducted on a property if a resident was not present at the time of the search.
Yes.
Okay, so then it's recommendation is to pass with some amendments. We'll apply the requirement that a notice be posted at the property to all warranted and warrantless search, regardless of whether the person is home or not. So you just have to post no matter what. Instead of the vague phrase callback number for one of the items required in the notice, instead use the description office contact number for at least one of the officers involved, and will address the inconsistency in the use of the word officer in law enforcement by using the word officer throughout the new subsection. And we did get prior concurrence from Senator Kai at the Public Safety Committee. Questions or concerns? If not, Senator Elefante.
Okay, Chair's recommendation is to pass SB 2236 SD1 with amendments of the 4 members present. Any no votes?
No.
No vote for Senator Wall. Any votes with reservations? Hearing none, Mr. Chair, recommendations adopted.
Thank you. Next up is SB 2405. This allows an election candidate, treasurer, or candidate committee to use campaign funds for the candidate's child care and vital household dependent care costs under certain conditions. Recommendation here is to pass as is. Questions or concerns? If not, Senator Elefante.
Okay, Chair's recommendation is to pass SB 2405 as is of the 4 members present. Any no votes or votes with reservation?
No.
No vote for Senator Wah. Mr. Chair, your recommendation is adopted.
Okay, thank you. Next up is SB 2529 relating to provider orders for life-sustaining treatment forms. Amends the definition of patient's provider and state law governing provider orders for life-sustaining treatment by removing language that requires the provider to examine the patient. This is commentary now. The reason for the bill is that these are patients planning for their end of life, what they want to have done to them medically at the end of their lives, and it isn't necessary for a provider to necessarily examine them for any reason, because it's really more of a legal planning thing. So recommendation is to pass as is. Questions or concerns? Seeing none, Senator Elefante.
Okay, Chair's recommendation is to pass SB 2529 SD1 as is of the 4 members present. Any no votes or votes with reservations? Hearing none, Mr. Chair, recommendation is adopted.
Thank you. Next up is SB 2565. This prohibits counties from prohibiting leashed dogs in public parks, establishes penalties for leaving dog excrement on public or private property. We'd like to accept the AG's suggestions to fix a typo and remove redundant language, and we'd also like to add a savings clause, i.e. It only applies prospectively. Questions or concerns?
The only comment I have, Mr. Chair, if I may, is the enforcement part, being at the city and county for nearly 12 years. I know there's a lot of support for it, but I think the important part is enforcement of this measure. Thank you.
Thank you. Other comments or concerns? If not, Senator Elefante.
Okay, Chair's recommendations to pass SB 2565 with amendments of the 4 members present. Any no votes or votes with reservation?
No.
No vote for Senator Awa. Mr. Chair, recommendations adopted.
Thank you. Next up is SB 2693. This establishes the offense of charitable fraud during a state of emergency. The recommendation here is to pass with some amendments. It appears that the retroactive date won't fly from a constitutional perspective. Ex post facto law, I believe, is what it's called. So we're going to remove that, but we'll put a bad effective date on it to move the conversation forward, because I think this may interact with other things that we're doing on post Lahaina fire. So the new effective date will be April 14, 2112. Questions or concerns? If not, Senator Elefante.
Okay, Chair's recommendations to pass SB 2693 SD1 with amendments of the 4 members present. Any no votes or votes with reservations? Hearing none, Mr. Chair, recommendations adopted.
All right, thanks everyone. We're adjourned.